Uh, Senators, this bill would ensure that a woman would receive child support from a man adjudicated or acknowledged to be the father, beginning on the possible earliest date of the child's conception.
Good evening, everybody, and welcome to the Pissed Off Parents Show. Hope everybody liked that little commercial I had made, The Matrix. Again, I'm an older guy. Matrix, that movie back in 1999 spoke to me, and it's just, man, like we're all in the Matrix. We got to get the hell out of it. We got to wake some people up here, and that's what I'm trying to do. We'll see how that goes. I did report last week and talk to everybody about some bills that are going to be up for committee tomorrow, and we got a number of people that are be going downtown to Austin here tomorrow. So I'm trying to think of all the names. I mean, I know Robert is. Let's see, the Godfather is going out there. There's going to be a number of people going. I would hope they either jump on the chat here or have it through other means as far as getting together and going down to the down to Austin and talking to the juvenile justice and family issues folks and giving them a piece of their mind and hopefully get them to see light. We'll see. I'm going to go ahead and pull up tonight, just kind of give everybody a lay of the land of what we're going to be doing here. Some is going to be just really kind of ad hoc, impromptu stuff here. But I'm going to go ahead and pull up the public hearing notice and then also talk about, we're going to go through each of the bills that are going to be up for discussion tomorrow, where everyone will get their 3 minutes of fame and talk to the overlords on the different pieces. And then also I'm going to talk about, if you're not able to go in person, some things you can do. And we'll get into that as well. Of course, we'll keep the chat line open. Any questions, comments, issues, whatever, we'll jump into it. So with that, let's go ahead and just jump into it right now. All right. So if you go to the link, I think it's actually in the on the invite here. I'm stuttering here. I've had a long day, so I'm trying to kind of keep my stuff together here. Not doing a very good job. But we got the public hearing notice. We'd heard, last week that a number of bills are going in front of the Juvenile Justice Family Issue Committee with Harold Dutton as the main dude, and then all the other folks around him. And they'll be listening, giving everyone 3 minutes of testimony time to say their piece and see where it goes. Up are going to be at the very least one or two, maybe more, of the retroactive child support bills. One of which actually I've have an email they'll be sending here shortly, but I sent it over to actually Robert to kind of help him, give him some ideas on what to say when he gets his 3 minutes of fame in front of the JJFI. And maybe if also as you're watching and listening, if you can offer other ideas on the different bills, then hopefully we can then craft that, send it as an email. And again, it's one of those things I would invite everyone to do, and I'll show you how to do that here in a bit. But let's go ahead and get into it. So tomorrow morning, bright and 10:30 a.m. Wow, these guys start a little bit late. But 10:30 a.m. For the folks that'll be there, they're going to go through, I think it's like 10, 15 bills. Then, or of course, had some substitution or some changes there. Actually, what I'll do is, just so if you want to follow along in your notebooks, I'm going to go ahead and include that in the chat so everyone can see that and follow along. And I'm going to do it in no particular order. and some of this will be me seeing it right along with you and us walking through it. That's kind of how I do some of these things. But so the first bill up is going to be, and as you saw, actually displayed is the order in which the bills are heard is at the discretion of the chair. So expect shenanigans and all that fun stuff. And if we know these guys, we know how they operate. So first up is HB 120. It's like a Morales bill here. It's relating to the terms and conditions of a standard possession order in a suit affecting the parent-child relationship. I'm going to go ahead and pull that one up here. Popping over to Legiscan, and we'll just go and look at the text. So it was introduced, the authors got Morales and then Swanson on there, of course, scheduled for public hearing. Let's go ahead and take a look at the text here. And I'll be honest, I mean, some of these will be the first time I'm really reading through these, so we're going to kind of get through this together. All right, so the first one relating to the terms and conditions of standard possession order in a suit affecting the parent-child relationship against standard possession order. There's your first, third, and fifth weekends, and the 2 weeks or the month in the summer, and then off centering, whatever. Basically, that 12 to 20% time with your kid, which as of last session, should have been, quote, replaced with the expanded standard basic or expanded standard possession order, which actually I find it funny because every session when the family board gets and does their spiel, they basically have said that everything but equal shared parenting, but the standard possession order is 50-50, and then the expanded standard is 50-50. So I always find it kind of funny that they can't even, I mean, their math sucks. We've got that and we know what they're really doing here, but it's just, whenever I see standard possession, that's just kind of what I think of, so my brain works. All right. So, again, basically it's talking to the general terms and conditions. Court shall order the following general terms and conditions of possession of a child to apply without regard to the distance between the residence of a parent and the child. So I guess this is going to be a timing thing here. Let's see. Managing conservator shall surrender the child to the surrender the child to the possessory conservator. That would be the non-custodial parent in layman's term at the beginning of each period of the possessory conservator's possession at the residence of the managing conservator. Yeah, apparently they haven't been watching what's been happening with the exchanges and stuff. Wow. And again, this is a Texas bill. We all know what a joke 2503 is in general. So yeah, let's just put another law in the books. Let's make it a state jail penalty, a felony to do it. Wow. Yeah. Sure. Okay, so we got that. I'll be here all night. I'm going to be talking smack about it all night. All right, if the possessory conservator elects to begin a period of possession at the time the child's school is regularly dismissed, the managing conservator shall surrender the child to the possessory conservator at the beginning of each period of possession. At A, the school in which the child is enrolled, which is existing, or if the child is not physically attending school, the managing conservator's residence, a location agreed to by all parties, or three, a location determined by a party who, following a finding under section 105.006C, is not required to disclose the party's address to the other party or is protected from the other party by an order rendered by the court. Okay, so I guess we're 2-3 years late on the bug thing. We're finally getting that in. I mean, is this honestly? I'm gonna leave chat up here. Is this really an issue? I mean, outside of just the general 2503 custodial interference thing, is this really something that is a concern? Yeah, Joe. Right. Yeah, right on, right on, right on. It's the last thing they need to do. Let's make exchanges take place where high conflict can take place. Yeah. So, pick a parent, whatever, pulls up in the driveway, and then the main squeeze has got their car in the driveway, and he's got a white knight or she's got a white knight, whatever, white queen, whatever. Yeah, we're going to see. I mean, we see these all the time. Anyone with an ounce of common sense knows what's going on with these custody exchange deletions. Yeah, let's do this. Okay, that makes perfect sense. It's like we've got common sense, and then there's the people at the legislature at that level, and they have none. They live in these ivory flippin' towers, or they're just clueless on purpose, and they do this kind of crap. It just makes absolutely zero sense. and I believe Texas actually has exchange locations. I mean, again, we had the what president or the main person years ago. They were talking about because someone always said, "Hey, do the exchange at a police station," and the guy that's like the president who has actually all the data is like, "Oh hell no, that's the last place you want to do that because that's where a lot of the violence happens." I mean, keep it at school. Good God. Let's see, Joe's also coming in here. During the school semester should be done at the school, so it's less interaction between the parents. Yeah, I mean, I had a 2-2-3 rap plan, and we exchanged. Essentially, the exchange was I would drop him off, drop the boys off at school, and she'd pick him up if she wasn't sleeping, and then vice versa. And it worked great. I had zero contact with her, and it was awesome. I loved it. That was the best thing. Yeah, Joe, you're raking them up tonight here in the Minnesota legislature. They're all dumb. Yeah, they're all dumbasses. I mean, it's like, and this is where I go. And I'm like, God, I was hoping I wouldn't go off on like a whole bunch of tangents, but here I am. These guys are dumbasses. I mean, I don't know how they got elected or how they got anywhere in this world. I mean, like dumb. There's there's like uneducated or not intelligent or whatever. There's that like you don't know. Like I don't know. Nuclear fission. I could hopefully maybe learn a part of it, or I know not to even get around it because I'm not smart enough to ever figure that stuff out. Whatever those things are. These guys are like dumb on purpose, and they think they're smart. That's the scary part. They actually think that they're somewhat intelligent, and they're stupid. They don't look at any data. They're just dumb. Yeah, this is stupid. And let's see. Okay, yes. I mean, it's talking. I mean, it's more of the same thing here. Let's just repeat the same words and put it in different spots and see if that works there. Then it's in time possession of a child ends the time school is scheduled to resume, and the child is not physically attending. School conservator in possession. The child shall immediately notify the other conservator that the child. Oh yeah, that's gonna work. Will not be or hasn't. Yeah, I mean, okay. Now, again, if you're hopefully jotting some notes down or whatever, I'm going to have some ways you can let your legislators know what you think, and I'll I'll preface it all by saying I don't want to use the word be respectful because again that gets misunderstood or misconstrued by whoever's hearing it for their own purposes. When I say be respectful, I mean don't be threatening, like overtly threatening or cussing, the typical I would say common sense stuff. But I would say let these people have it. Like are you like this one? Are like are you dumb? I mean, we've got who knows how many custody exchange violence scenarios. I mean, the one, of course, Darling, what's his name? Tyrone Darling last year. There's one just, of course, since I was out there at the event, of course, sticks in my head. But we have those scenarios. We have all these things where at the house, we have, and then this is like their response is to like invite this. Like, are they stupid on purpose? It's like you want to tell them, dude. I mean, it's you. We're having deletions or we're having violence in this scenario. Why are you making a law that does that? And then I don't know, like take care of the laws that we have. It's I don't know, it's a dumb law, but I don't know if you can find a way to write that in a smart way or something when it's time to send an email or if you're planning on going to Austin. I think The Godfather is supposed to be testifying on a number of bills. I personally want to see how The Godfather is going to intelligently discuss this one with them without like dropping f bombs. And that's one of the many reasons why I don't go to Austin. Is well, one, work and other commitments, health. There's a myriad of reasons why I don't. And that's one of them. I don't have that ability to kind of keep my composure when dealing with these morons. That's just something as I've gotten older, I don't have that ability to do anymore. Anyway, okay, so yeah, there's that one. Um, do with that what you will. Go. All right, let's go down to the second one here. And again, if people have any questions or whatever, yeah, shoot them out here. But we're just going to kind of go through each one of these bills. HB 461 is Smith relating to a waiver of the requirement for the performance of an adoption evaluation in certain suits for adoption. Okay. Let's see what this has. Okay, relating to the way. Okay, whatever. Okay. I guess they're looking for more of that Title 4E money here. See, except as provided for subsection A1, the court shall order the performance of an adoption evaluation to evaluate each party who requests termination of the parent-child relationship or an adoption in a suit for the termination of the parent-child relationship in which a person other than a parent may be appointed managing conservator of a child, or an adoption. A1 is in a suit for adoption that is uncontested. The court may waive, the requirement under subsection A for the performance of an adoption evaluation. Oh, okay. Yeah, get them out quicker. Of an adoption evaluation of the prospective adoptive parent if the prospective adoptive parent is a step parent of the child, and the court has reviewed investigative records of the department and any criminal history record information maintained by the Department of Public Safety relating to the prospective adoptive parent. Okay, the cost of conducting an adoption evaluation required under subsection A, or reviewing investigative records of the department, criminal history record information maintained by the Department of Public as applicable. Okay, shall be paid by the prospective adoptive parent in the suit, okay, unless court waives a requirement for the performance. Okay, so this is an adoption scenario. And we know we have the unwilling adoption scenarios where children are being adopted out from underneath the parents, which this also covers. We have to think about that. So it looks like, again, what I'm reading here in the normal vernacular here is that they can basically waive the performance adoption evaluation if the prospective adoptive parent is a step parent of the child. So Sally divorces her husband, or they break up, divorce or break up, whatever it is, and then she gets her new main squeeze, and then they're able to go through this process to have the new dummy adopt the kid. Is basically, and then instead of having an evaluation, they're just making it a little quicker, and so they can just kind of run that on through. I mean, that's one scenario that I'm going. This really doesn't make any sense. There's not a good thing there. If it's a step parent, that's kind of weird. I don't know. I mean, again, Texas, didn't you get? I mean, didn't you get your asses handed to you with the whole put family first thing on all this? I mean, shouldn't you reevaluate that? You guys lost what, 40, 70, whatever $1 million in Title 4E money because you guys couldn't put family first. You were so money hungry. You circumvented that process and you got your butt handed to you. Looks like you're doing more of the same. I mean, this is just kind of a dumb bill. I'd love to hear the reasons that where the use case where this would make sense. I mean, as a data guy, as a whatever, there may be. We've got a million families and 99.9% of them. This makes sense. But when I see the step parent of the child being able to kind of just waive that whole process, that is a little concerning to me. Um, then the other thing is that the court has reviewed investigative records of the department, any criminal history record, information maintained by the Department of Public Safety relating to the prospective adoptive parent. Yeah, I mean, I've got no faith in the judiciary. I'm assuming everyone that would listen to this show is in the same boat. I've got no faith. I mean, like they don't review information anyway. They just basically take their feelings and run with it. So this kind of doesn't make any sense. Kind of crazy. Anyway, all right, so that'll be another one. We'll see what people decide to do on that one. All right, we're gonna breeze through. We're gonna have some good ones coming up here. Oh yeah, here we go. HB 532 Patterson. This is one of those the relating to the establishment of parentage and the duty to pay child support. This is one of the retroactive child support bills. You got Patterson, Anderson, and Swanson. God, I don't want to let her back on. Okay, so and I've read, well, we've got the five bills, one in the Senate, four in the House. I've read them all. They've done their undercover of darkness. At least the SB, well, the SB one, the Senate one, they did their undercover of darkness. They're obviously full of crap. And then the HB ones have been modifying theirs as well, I guess, following suit. And I'll pull it up for this one, and then I'll save it till we get down a little bit further to the other ones here. But it just a lot of dumb stuff on these. Let me see here. I just want to make sure this language, because I just want to kind of skip down to the other one. Okay. And just for those that don't know, again, this is one of the five bills, HB 532, that for retroactive child support. So at conception of the child, the courts will basically do a bundled jumbo debt, the super duper debt, slam it on the guy, and then depending upon which bill passes through, they either immediately start getting charged interest, the 6% per annum, or they'll get a year moratorium or time they want to pay interest on it with that. So again, with all these bills, what's going to happen is when you go into court and the judge says, okay, well, prenatal, postnatal, and all this language is going to be still using the old language of the crib and diapers and all their nonsense. But they're going to basically, the judge is going to, look at your credit report, look at your finances and all that, and go, yeah, you owe mom through Title 4D $10,000. Boom, judgment. You get a lump sum, so you're going to have that. Then you're 20% going forward. So that's what every kid, man, whatever has to look forward to when these bills pass. But let's look at this one. I just want to kind of take it, look at it on its face and see if it's not word for word like the other ones here. So this one, okay, retroactive child support on adjudication or acknowledgement of paternity, notwithstanding any other provision of this chapter or other law, and the order rendered under Chapter 160, establishing a man's paternity of a child, or in any suit to establish child support obligation of a man whose paternity has been established by the execution of a valid acknowledgement of paternity in regard to the child under subchapter D, Chapter 160, which actually I have up on another screen. Court shall order the man to pay retroactive child support for the child beginning on the earliest possible date of the child's conception as determined by, okay, this is reading word for word with Cook's revisions. And I'm just going to say it right now. You need to get billboard ads, shout it from the rooftops. You need to tell every dude out there, do not sign the acknowledgement of paternity. Absolutely refuse. Because once you have signed that, you are on the hook. It's in reading through the family code, they have buttoned that one up really good. There is just no other way around it. How they've done that. So, guys, everybody, hopefully you've watched Story Time, the video that I put out yesterday. It's really get yourself educated. You need to tell everybody every guy do not sign the acknowledgement of paternity. That is I'd put that up there with one of the dumbest things you can do, dumber than peeing on an electric fence. I mean, it's just stupid to do it. I don't care what kind of price you're getting from the old lady. Do not sign it. That would be the dumbest thing. I mean, we just need to have bastard children here on out. It's done, because once you've done that, you have royally screwed yourself. They've buttoned everything else up. Okay, in ordering retroactive child support under this section, the court shall, meaning will, apply the child support guidelines provided by this chapter and, on a proper showing, order the man to pay an equitable portion. Okay, this is word for word with Cook's bill. Also, I'll just end up probably just skipping down to his. Notwithstanding Section 157, 261, or any other law, interest does not begin to accrue. Oh, God. Yeah, okay, the first anniversary. So this is word for word. Let me make sure it's totally word for word. Yeah, it is made by the pregnant mother. I'll pull up the letter or the email that I'm going to be sending to the committee as well. Well, actually, I already sent it to Robert on my response, so you can use it however you want to if you're going to create your own, which I would recommend you do. I mean, chances are they're not going to read them or do anything with it, but at least you've done something on the Titanic as it sinks. But yeah, it's got the same just complete garbage in here. This is word for word the same bill as Cook's, and both are going to be heard tomorrow, 532, and I think it's 1730 something or other. Where are we at here? Yeah, crap. I didn't copy that part of the link in there. Actually, I think it's on my Word document. Yeah, it's 1734. So those two bills are word for word the same, which is, I would say funny if it wasn't so sad with what's happening with that. All right, so when I get down to Cook's bill, there's a section that I kind of want to make sure I'm talking about Cook's bill that kind of ties in. I gotta have some fun with this crap, or I'll go nuts or nuttier than I already am. So yeah, got that. All right, so the HB 811. This is relating to the reporting and investigating certain cases of child abuse or neglect involving a pregnant person's use of a controlled substance. Oh, God. All right, I might am just getting pissed off here. I just have a funny feeling. I already know where it's going to go, and it's going to just be one of those. You've got to be kidding me. All right, you know what? Going to let it all go and just go. All right, HB 811. All right, B2. A professional providing prenatal mental health or other medical care to a person who voluntarily discloses to the professional that the person illegally used a controlled substance as defined by Chapter 481 Health and Safety Code during pregnancy is not required to make a report under this section if the person, again, these are your legislators. I didn't pick them. Trust me, I did not pick these guys. These are the people writing your bills. The person provides proof that the person is currently enrolled in or has recently completed a substance abuse treatment program. Sorry, I can't get through this. Or the person made reasonable efforts to enroll in a substance abuse treatment program within 5 days after the date the person made a disclosure described by this subsection, or the professional determines that there is no immediate risk of harm to the child from the exposure to the controlled substance. Wait, of the okay. Well, you know what? Everyone makes mistakes. Apparently, writing is one of theirs. And the person does not otherwise pose an immediate risk of harm to the child. Oh shit! These are the laws, guys. This is what we're wasting our this is the pussy pass, and it's just this is ridiculous. Okay. All right, let's go try to skip down here and we'll go back and evaluate. See, the department may not investigate a report of child abuse or neglect allegedly committed by a person based on the person's illegal use of a controlled substance, as defined by Chapter 481 Health and Safety Code during pregnancy, if the person enrolls in and successfully completes a substance abuse treatment program under the supervision of the referring or treating professional. Okay, guys, what in the actual fuck? I I'm hoping to God people are I the, people have actually like wrote these words out, and I'm hoping people would fucking wake up. Uh, we've got a bill here. Basically, it's giving a pussy pass. So this chick is smoking meth. I mean, when we're talking about pot, and everyone's got their own personal opinion on it. Is weed good or bad? Whatever. We're talking about meth, fentanyl, illegal substance during pregnancy, guys. During pregnancy, doing this stuff, and they don't have to be reported. They get a pussy pass. This dudes, you should not be having sex with any of these people. Like go monk. This is ridiculous. Uh, I mean, I'm like, what? I can't even think of the right dumbfounded word to use. I mean, this bill, which is actually, I mean, 20 years ago, 30 years ago, I wouldn't have even thought this, but can you imagine? We live in a society, we live in Texas, a state where this bill was thought of, written down, and people are trying to pass. So little Sally, and that's my new term for Goofy, little Sally's got a little meth problem. Well, we don't want to hurt her feelings because she makes us so much money in state funds and everything else, and we just can't hurt the poor widow girls. But she's doing snorting coke well, I can't say off a hooker's ass, but off of whatever. she's like snorting meth, smoking meth. Tells you how smart I am. She's smoking meth and she's getting a pass. It's okay. When common sense, aside from all the data, that you're going to cause irreparable damage to your child. I mean, okay, 30 years ago, even, when if you saw a chick smoking a cigarette while she was pregnant, you thought she was the biggest piece of trash in the entire world. Am I right, everybody? Now she's got her coke pipe or crack pipe. I don't even know this stuff. She's got her crack pipe, and she's all like, "No, my baby, it's my baby." I mean, are you kidding me? They're actually going to talk. They're actually going to talk about this. These people need to, I mean, whoever is going there, they need to be shamed. Like the goofy broad that wrote this thing, what Meza, if it's a, I don't know, if it's a chick or a dude, they need to be shamed, like publicly shamed. Like, how dare you write this piece of trash? What the hell is going on in your brain? That is ridiculous. I mean, what the bill should say is if you have illegal substance in your system, goes to dad, or hell, goes to the CPS, and they can see if they can hook them out or whatever. This is absolutely insane. I just, again, another reason why I don't go down to Austin, because I can't deal with these morons. I mean, I don't consider myself to be that smart of a guy. I've just read a few things. I can read English. I mean, I'm able to, I don't know, somewhat converse with people, kinda. These people are morons. They're not. They are just beyond unintelligent. And it just pisses me off that we're actually spending, like, they're going to spend 3 minutes or time talking about that. It just the stupidest thing. All right, clear that bit of dumps. I mean, and that's the other thing too. Emotion, I'm not able to kind of like keep up with this. I'm getting older, and the amount of tomfuckery and just stupid nonsense here. It's just I can't. I don't physically have what it takes to keep up with the stupid, because everything it's just insane. But all right, let's just keep going. HB 891. So relating to the use of, oh god, relate. I wonder if this is like I'm on Punked. Like this is all a big joke. Like Ashton Kutcher's gonna jump out and go, no one's that dumb to do this stuff. All right, relating to the use of expert testimony to challenge the qualifications of or methodology used by a child custody evaluator in a suit affecting the parent-child relationship. Let's see what we've got here. Okay. Okay, we already said that part. Family code, that worthless piece of parchment. Notwithstanding subsection a party is not prohibited. I love people that use the double negative. That was like big, like 20, 10, 15, 20 years ago. I hate people that do that. Anyway, notwithstanding subsection a party is not prohibited from using expert testimony to challenge the qualifications of or methodology used by a person who has conducted a custody evaluation relating to the child under subchapter D, section 107. Okay, this one actually might, I mean, for folks that I think would be impacted here, this is one of those things where, as we all know, the custody evaluations that come out are complete dog shit. Um, and they come out and they're just, it's whoever paid the most money, or whoever the judge wanted it to get. So it looks like this bill here would give you a party is not prohibited, it's that double negative thing, from using expert testimony. So I guess also what's expert testimony? I mean, you got, I mean, is Brooks McKenzie going to have like 10 million clients now? I mean, is it only a certain number or whatever, but, or a certain group, how that's going to work? But yeah, I mean, I guess on the surface, this seems like an okay bill. that you're able to use expert testimony to either disqualify the custody evaluators documentation. So I mean, all in all, I mean, so far the crap I've seen, this isn't that bad. So yay, one for what, Spiller. Okay, good God. All right, moving down the old list. Okay, oh nope. All right, this is a different one. All right, HB 980 from Cook, relating to the privilege against disclosure of certain collaborative family law communications. Oh, now. Family law attorney wanting to, well, I'm not gonna go in there biased or prejudging, but let's see what we got here. Um, oh wait, so this is just hold on, let me make sure. It should be existing. All right. Okay, so family code amended to read as follow. A, the privilege prescribed by section 15.114 does not apply to a collaborative family law communication that is, one, in an agreement resulting from the collaborative family law process. Oh, God. Evidence in a record signed by all parties to the agreement. Okay, here I go. Subject to an express waiver of the privilege in a record or orally during a proceeding if the waiver is made by all parties and non-party participants, available to the public. Family law, available to the public. Okay, whatever. Under Chapter 552 Government Code, or made during a session of a collaborative family law process that is open or is required by law to be open to the public. Threat or statement of a plan to inflict bodily injury or commit a crime of violence. A disclosure of a plan to commit or attempt to commit a crime or conceal an ongoing crime or ongoing criminal activity. A disclosure in a report of suspected abuse or neglect of a child to an appropriate agency under Subchapter B, Chapter 261, or in a proceeding regarding the abuse or neglect of a child, except that evidence may be excluded in the case of communications between an attorney and client under Subchapter C, Chapter 261, or abuse, neglect, or exploitation of an elderly or disabled person to an appropriate agency under Subchapter B. Sought or offered to prove or disprove a claim or complaint of professional misconduct or malpractice arising from or related to a collaborative family law process. Okay, I'm going to keep an eye on that one. An allegation that settlement agreement was procured by fraud, duress. Let's name one that isn't. Good God. Coercion or other dishonest means, or that terms of the settlement agreement are illegal, or the necessity and reasonableness of attorney's fees and related expenses incurred during collaborative family law process, or to challenge or defend the enforceability of the collaborative family law settlement agreement. Then there's striking out a claim against a third person who did not participate in the collaborative family law process. I don't know what's collaborative with a lot of these, but okay, so talking about privilege. Okay, so the privilege, I assume, is the section I could pull it up, but I'm 99% sure is that section 15.14 is the attorney-client privilege. It doesn't apply if it's an agreement resulting from the collaborative family law process, evidence in a record signed by all parties to the agreement. My only concern there is I've heard more than a time or two that the counsel that represents a schmo, they will sign on their behalf and like not get their approval, and like little games like that get played. But again, this is the privilege does not apply. So we got that. Let's see, subject to an express waiver of the privilege in a record or orally during a proceeding if maybe the orally word's throwing me off during a proceeding if the waiver is made by all parties and non-party participants. Okay. So yeah, they'll have you sign waivers, and again, that's general common sense advice that's out there, or that I tell people all the time. Do not rely on your attorney. I don't care if good, bad. I'm not going to go down that rabbit hole. But they aren't you. You need to get educated on the law. At least have it's like your mechanic. You may not be able to figure out the flux capacitor of X car, blah blah blah, but you understand the workings on how it works, and you can read certain things. You need to read everything that's put in front of you, and do not take the attorney's word for it. If it smells weird, don't do it, because these guys are all in league together. So I don't know how many times I gotta say that to people. There's so many times, oh, I got screwed over in court because this, and this. My attorney did this, or their attorney did this, and I'm like, did you read it? No. Well, you got what you deserve. Playtime's over. I'm sick and tired of wiping people's noses on this crap. All right. All right. So it's not prohibited. Okay. If there's a, okay, that's not a big deal. The threat or statement of a plan to inflict bodily injury or commit a crime of violence. Okay. I can see both sides of that. I mean, we all know about the Cass Jackson situation. Pro con, agree with it, don't agree. That's not even something I'm going to go into. But it's talking about that. I mean, that was an instance or a situation there. I can kind of see it. If you're sitting there talking to your attorney about you're going to go ahead and delete the other party or all the attorneys or the judges or whatever. I can see how that shouldn't be attorney-client privilege. I get it. So that's I'm not going to have too much heartburn over that one. I mean, I tell people, don't be telling people if you're going to do something or if you're blowing off steam or whatever. Find a good buddy, make sure there's no recordings, and blow off steam that way if you gotta. I'm more of a do, don't talk, do, regardless of what that is. I hear these people all the time that the blah blah this, blah blah that. It's like put up or shut up. And I'm not just talking about this kind of stuff, just in general. Quit run your gums. Either you're going to do it or you're not. Don't tell me what you're going to do. Do it. Okay. Can I see ongoing crime? Uh, that one could get. I mean, for some people, I guess could get dicey because you're going through a divorce and you've been doing some things or whatever. That may be interesting, but I can see why they're trying to cover their butts. And then, yeah, the whole suspected abuse or neglect of a child to an appropriate agency. I think it goes kind of in parts of the other bill that if they're talking about abusing a child or have abused a child or whatever, that should probably be kind of an off limits thing. But if you're sitting there and your attorney asks you point blank, like, hey, this person's alleging this, did you do it? And you say, yeah, then I mean, this is gonna basically make it okay for them to report you or whatever, or confirm it. So, yeah, this one I'd say that's just be something. I mean, I'm not neither ticked or not ticked about this one. This isn't like real dumb. It's just kind of it is what it is. All right, so that's that one. Let's see, Hull. Okay, relating to court orders to aid in investigation by the Department of Family and Protective Services. Those lovely individuals. Okay, so blah blah blah. Family code. Okay, if admission to the home, school, or any place where the child may be cannot be obtained. Oh boy. And if the court having family law jurisdiction has probable cause to believe that an order is necessary to protect the child from abuse or neglect, then the court shall order the parent, the person responsible for the care of the children, or the person in charge of any place where the child may be to allow entrance for the interview, examination, or investigation. All right, I'm going to keep reading before I go back there and have some thoughts, and I would just recommend anybody else wants to jump in there. I'm hoping to God anyone that's on is like hearing this stuff and kind of freaking out and just thinking. And I guess take the rose-colored glasses off when you're looking at these things, because if you know anything about attorneys, they'll say one thing and then those exact say this is all done. A lot of this stuff is done. They craft it a certain way so that they can then have things have dual meanings that aren't intended, like when they're explaining it to you, and they use it for nefarious reasons. And that's where I would say a lot of people need to, figure that part out when they read these things, because yeah, that's what happens a lot of times. That's why when we get the retroactive child support bills, I'm gonna have a little bit of fun with that. Anyway, all right, so we got a hearing for an order under subsection B may not be ex parte unless the court has probable cause to believe that an immediate risk to the physical health or safety of the child makes it impractical to hold a full hearing. So basically, they can just paper. So right now, for abuse and stuff like this, there's a 51% rule, which none of the judges are doing anyway to do a lot of this crap. They're doing like I think 5% as far as the threshold to drop these orders and do all this crap. What I'm reading here is basically they can just write these things, just rubber stamp and get them out the door. So if someone's got a beef with you, whatever, and high up, and we know that the stuff runs deep. They can do whatever the hell they want to. They can get a rubber stamp. Oopsies, we're doing it for the best interest of the kid, and kick those out the door, and there go your kids. All right, court that holds an ex parte hearing authorized by subsection B1 shall prepare and keep a record of the oh God, keep a record of the hearing in the form of an audio recording on request of a party to the suit. On request. Oh wait, did it? Oh wait, no, separate section. Stand corrected. On request of a party to the suit, the court shall provide a copy of the record of an ex parte hearing to the party. So, under cover of darkness, they steal your kids. You're freaking out. You have to, of course, know that you have to request it, which I'm sure has to be done standing on one foot on a Wednesday, facing east at 2 o'clock in the afternoon, kind of thing. And that's how you can get that if the recording doesn't mysteriously disappear. So, what I'm again gathering from this, and again, love to be proven wrong, is that they're basically opening this thing up to where they can basically come in your house. They don't give a crap. And again, we get to that whole, the courts. Anytime these broads, pull your ass into court and just get everything going, your kids now are wards of the court. I mean, that's how it works. So that's where that's going to come in. So if they basically decide to come in, there you go. When my ex moron, when she was pulling her shenanigans, CPS came to my kid's school, yanked them right out, sat them down, asked them all kinds of dumbass questions, and just scared the crap out of them because, of course, they do what they do best, and they're basically your dad's a piece of crap, and here's why. Does he have this? Does he do this? Does he do this? And my kids who then were like in third grade were like, no, no, no. Yeah, he's good. No, he doesn't hit it. The typical. I mean, well, the responses that kids would give with a good dad, and of course they found nothing. But they were able to do that. This is going to give them just full whatever they want to do. So this would be a good one for folks to talk about limiting their powers. But this is that next level, and they're going to whine and tell you it's for the good of the kids, which. If anyone here has been in Texas for any length of time and witnessed all this nonsense, they don't do diddly squat for the good of the kids. All right, so you got that one. All right. Oh wait, Hull's doing a double shot here. Oh, he's one of the relating to the contents of a petition in certain suits affecting the parent-child relationship. Let's see what HB 1087 has here. Boo, here we go. Okay, amended to read as follows. Okay, filing petition before taking possession of a child. An original suit filed by a governmental entity that requests permission to take possession of a child without prior notice in a hearing must be supported by an affidavit sworn to by a person with personal knowledge and stating facts sufficient to satisfy a person of ordinary prudence and caution that 1. There is an immediate danger to the physical health or safety of the child, or the child has been a victim of neglect or sexual abuse. 2. The continuation in the home would be contrary to the child's welfare. 3. There is no time consistent with the physical health or safety of the child for a full adversary? Maybe advisory? I don't know. Adversary hearing under subchapter C, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to prevent or eliminate the need for the removal of the child. The affidavit required by subsection A must describe all reasonable efforts that were made to prevent or eliminate the need for the removal of the child. So your section 2 is amended. Temporary order, temporary restraining order, or attachment of a child rendered by the court under subsection A must describe the reasonable efforts that were made to prevent or eliminate the need for the removal of the child as required by subsection A4. Okay, so they either which way they keep and don't keep, and they have to do facts and findings or reasoning for it. All right. Affidavit required by subsection B must describe all reasonable efforts that were made to prevent or eliminate the need for the removal of the child. If the court does not order the return of the child at an initial hearing under subsection A, the court must describe in writing the reasonable efforts consistent with the circumstances and providing for the safety of the child that were made to prevent or eliminate the need for the removal of the child. Okay. All right, so it's just kind of updating the different sections. If at the conclusion of a full adversary hearing, the court renders an order under subsection G or G1, the court must describe in writing reasonable efforts. Okay, same. Continuing danger if the child's return home, reasonable efforts that were made to enable the child to return home, and the substantial risk of a continued danger if the child's return home, as described in subsection G3, or the reasonable efforts that were made to enable a person's possession of the child and the continuing danger to the physical health or safety of the child, as required by subsection G1-2. Okay. So this is just, I guess, one with I guess of CPS or whatever agency is going to take your child. Talking about immediate danger and stuff like that, which I thought CPS kind of already had. I don't know. I don't know. This is again. I was with the things that have happened with CPS in general, and what all the other things that are going on. I mean, I would say in a perfect world where we all cared about children, if this bill was written with that in mind, I guess I could see, hey, if you take the kid, you need to have reasons for doing so. You can't just take them and be like, yeah, whatever. And if you decide to leave the kid in the house, you better, or you need to put reasons why, the parents are doing good, or whatever that is. And I don't pretend to know every situation that a kid can be in. But I just know that was it 80% of all CPS items out there are proven to be false when they go through the divorce process. So that's where a lot of these things are. They need to actually introduce a bill that if you file a false CPS report, that you get in trouble instead of doing the old silver bullet and all that stuff. That's all. Yeah, that bill will never see the light of day. Too much money in there. I don't know. I mean, I don't know what to even good or bad. I mean, it is what it is. I mean, it's not a hill to die on for me. It is what it is. I'm just more of a limit at this point, limiting anything I do to limit their powers or to encroach on my life or anyone else's life. Yeah, I mean, I'm not really a big fan of it. All right, moving down. We're getting down there. Oh, there's Leach's bill. All right, Campos, HB 1499, relating to the duties of a court-appointed guardian ad litem, the old Gaul, attorneys ad litem, and amicus attorneys in certain suits affecting the parent-child relationship. Oh, I think this is the one I'm going to have fun with. I don't know. Let me see. Guardian ad litem appointed for the child under this chapter shall, no later than the 7th business day after the date of appointment, interview the child in a developmental and appropriate manner if the child is 4 years of age or older. Each person who has significant knowledge of the child's history and condition, including educators, child welfare service providers, and any foster parent of the child and the parties to the suit, seek the elicit in a developmentally appropriate manner the child's express objectives, consider the child's express objectives without being bound by those objectives, encourage settlement and the use of alternative forms of dispute resolution, and perform any specific task directed by the court. A Gaul appointed to the this is kind of dumb. I mean, Gaul, you got an attorney representing a child. Okay, anyway, to represent a child in the managing conservatorship of the Department of Family and Protective Services shall at least 72 hours before each scheduled hearing determine whether the child's educational needs and goals have been identified and addressed. As men read as follows. In all, not a Gaul, in all, appointed to represent a child, amicus attorney appointed to assist the court, blah, 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 text disciplinary rules of professional conduct, and no later than the 7th business day after the date of the appointment interview, the child, okay, so it's just kind of rehashing, rinse and repeat for those different roles there. I don't know, I mean, Yeah, 17 hours. I mean, some of the stuff is like whatever, but I don't know. It's like you get a divorce or you're breaking up. I mean, like you got your attorney, she's got her attorney, the kids have their attorney, the attorneys have attorneys, the attorneys for the court. I mean, it's like good God. I mean, we wonder why this nonsense gets as crazy as it does. It just makes no sense. Kind of just skimming through here, yakking. 'Cause, yeah, it's just basically a bunch of damn words that it's just all whatever. And I'm just trying to, I don't know, it's just like having all these like attorneys and stuff on. I mean, we divorces and breakups and all that stuff. You shouldn't have all this nonsense. I mean, all this money that's going in there. You got, I mean, all these different attorneys and all these. It should be like it. They should really be passing laws about collaborative divorce and breakup where you sit both the idiots down and you show them the damage to their damn kids by playing their stupid childish games and all other crap. And you figure out, which one makes sense. You start out equal shared parenting and then you move on. Oh, wait, there's no money in that. Never mind. Now I understand why they're doing this crap. It's just, I mean, it's like, it's like a septic tank and they just keep piling more crap on top of it, hoping it's going to get better or, well, they can make more money. I don't know. This is just one of those ones where the Titanic's already sunk on this stuff. I mean, kids are already wards of the state across the board. I mean, you don't. I hopefully no one here thinks for a second that they're the ones that are legally, able to raise their kids. I hope to God no one is dumb enough to actually believe that. I mean, the state has done everything they can successfully to take all your rights away. I mean, in a heartbeat. I mean, health is crap. I've been reading here for the last half hour or so proves that beyond a shadow of a doubt. And we all did it. We all let it happen. But anyway, yeah. I mean, this is kind of where it's at. Again, my whole thing is, man, don't get married. Don't get with a chick. Just don't. Don't even. Don't even rap it anymore. You, basically, MGTOW, red pill, monk. Stay away from it. Let it all die out over the next couple decades, and then start fresh, like a new whatever. I mean, it's insane. This stuff. These people are freaking idiots. Let's see here. We've done Campos. All right. Let's see. Jolanda Jones. Let's see what we got here. Oh shit. Oh, this is gonna be a good one. All right, I got stay awake. Grab some soda. I think this is gonna be a good one. I think we're gonna get one here. HB 1695 relating to the enforcement of an order to pay child support by contempt.
But pissed off parent, isn't it illegal? Isn't it a violation of one of our like amendments or something where you can't go to debt or go to jail for paying a debt?
Well, Sonny, it's not that way because it's contempt of court, and that's why you go to jail. All right. So anyway, Jones and Harris. Blah, 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 blah. Okay, D. The court may not find a respondent. Oh, whoa, whoa. You know what? I'm about ready to eat some crow, I think. The court may not find a respondent in contempt of court for failure to pay child support if the respondent appears at the hearing with one, a copy of the payment record or other evidence satisfactory to the court showing that the respondent oh good God, is current in the payment of child support as ordered by the court, and two, evidence satisfactory to the court showing that the respondent's failure to make timely payments was due to an error made by a third party or other circumstances outside the respondent's control. Okay, basically, this is called the OAG incompetence bill because the overwhelming majority of child support for Texas specifically goes through the OAG clearinghouse by wage garnishment because again that's the maximizes the Title 4D funds and all that fun stuff. And what's funny, the way the law reads is that if that like you have no control over how that process works. The letter goes to your employer, they start garnishing your paycheck, you've got zero say in it. If they screw up, you go to jail for that. I wish I would have seen this earlier. I could have had a thing actually on the pissedoffparent.com site. If you go under child support, I think I have a few videos in Texas where guys have gone to jail for overpaying their child support as a result of the OAG screw up. That's how stupid this all is. And it sounds like they've actually had to put a bill in place that if they were able to show that they paid it, that they won't go to jail or won't be in contempt of court. I mean, it's the same. It is the same thing. Um, I mean, it's kind of dumb here. I mean, basically, they've actually had to waste time writing a bill because the OAG, which, if you listen to the SB bill, the head of the OAG or the higher up, whatever, King morons, they admitted that like their system can't even handle what they have. They have an old mainframe system and again, I've worked on mainframes for decades. They're actually very solid if you do them right. And then they spent what $60 million on the new improved OAG thing, which was a big turd that they basically lost their shirt on. Is like $60 million, and they've been quietly trying to get rid of that little mess up. But yeah, they admit they can't even handle what they got today because morons control all that. Yeah, get some COBOL programmers. Anyway, so the system screws up or whatever, and then this guy gets slammed and goes to court because he's apparently behind, which he has zero. It's just crazy. And again, if you don't believe me, read your child support orders. Mine was in my divorce decree. It talks in there specifically that of course I've got no control over it, and if the system, the OAG system screws up, I'm still at fault. It's still my responsibility. I mean, that's how screwed up this is. This is what we've allowed to happen. But anyway, they've had to put a bill in place. I mean, I think out of all the stupid, moronic, whatever, I mean, I can see why this bill is around. Probably enough guys are going to be or have gone to jail over this, and it's just ridiculous. And they're going to put a bill in place to do that. Now, where I think people are going to get caught is they're going to like show up for their contempt hearing because what happens a number of times. We'll never know because they don't allow cameras in the courtroom. But a number of times these guys show up with whatever evidence they have, and the judge says, "I don't believe it. I'm not going to look at," which actually happens all the time. And then throws their ass in jail anyway. So we're going to get a lot of dummies here that are going to show up thinking they're going to get a fair deal, and well, they're going to get three squats and a cot or whatever that old saying is. But anyway, that bill's there. I'm sure there probably won't be a whole lot said on that one. I'm hoping people are going to be shaking their heads like it's crazy. We actually have to have this bill because you morons can't do your system right, and we can't sue you because you've given yourself an indemnity or whatever it's called. I can't remember the word for it, but just crazy nonsense. I mean, make sure. Okay, I just want to make sure Cook's bill's there because I feel like I got a really good comeback for this one. When we get down to Cook's, I don't want to do whatever. So we're gonna have a total of, I believe, no, we're gonna have four. All four of the retroactive child support bills are going to be heard tomorrow. So this should be fun. So this is which knucklehead is up for? Okay, Leach. Yeah, and Jeff Leach, strong Republican, equal shared parenting guy and advocate, and he's with us, and he believes in equal shared parenting, and he's for fathers' rights, and he was the first numbnut that. I believe he was the first numbnut that drafted a bill for retroactive child support. So, oh god. Oh, okay, Joe. You say 3 hots to cot. That's it. I'm getting old. I don't remember half this crap. Okay, so retroactive child support. We'll see if the language. And I'm sure no one's been as goofy as I have. I've been following these bills. Actually for years at the federal level. And you can see more of the information on pissedoffparent.com under child support. See some data on that. I mean, I've been following this crap for years, and I called what was going to happen. But anyway, whole separate thing. But been following these since they've been drafted, and it's just funny because the language came out one way, and then they did this undercover of darkness thing on the SB bill, and then they're modifying the House bills as well. It's basically like a bunch of velociraptors like attacking the fence just to kind of give you a visual, and they're trying to figure out what and again just sheer numbers. I mean, it's a lot of stuff to keep up with. But anyway, all right. So retroactive child support. on adjudication or acknowledgement of paternity. Again, guys, do not sign the frickin' DNA or the birth certificate. Do not do it. That if you have any conversation with anybody about anything, tell them do not sign the birth certificate. Refuse. Not that that's going to matter down the road anyway, because they're going to cover that crap under the adjudication part. But anyway, let's see. I just want to make sure. I'm going to scan through this. I'm going to, blah, 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 blah. So I think it's pretty well the same word for word, shockingly, as the other ones with all the. And again, when I talk about like they revise under cover of darkness, everyone hopefully remembers language like the crib and Pampers and prenatal, postnatal, Gucci bag. Car for the woman. Yeah, and I'm joking about some of those. I'm being funny or trying to be. And then when it became obvious they were going to get their asses handed to them, they like last second amended it. Didn't give anybody the amendment. And then the only person that got to read it was the head guy at the office of the attorney general, and he actually didn't go far enough with what he was even talking about. But it was they're changing. They're again velociraptors. Okay, so check with the court shall order the man favors of some support. Okay, so this is word for word so far on there, and again this whole leaving up to the judge. Now the thing that, and I said it a little bit earlier, and I'll dig more into it when I get down to Cookie's bill, but the prenatal and postnatal healthcare expenses. That is ambiguous language, and when we talk about Cook's bill, we're going to dive into that more because people need to wake up to what this stuff actually is. Remember that attorney nonsense and using one word here and one what that means. I mean, hopefully everyone's got enough background in contracts or have been screwed over by contracts. To know that things are written in a way to say one thing up here and then screw you from behind. That's kind of funny. Anyway, okay, blah, 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 first anniversary. Okay, so they're giving that 30 or 1 year anniversary for that 10,000 plus dump of cash on that 18-year-old kid. See, they do the same thing. The pregnant mother. Oh, poor mommies. I cannot wait to obliterate this one. The order render. Okay, yeah. All right, yeah. It's all the same nonsense. All right, so I'm gonna skip over that one. Is again rinse repeat. None of these guys have a good idea between them. Okay, another support order. This is done by HB 2246 by Smithy. Okay. An assignment bar limited. Okay, person. Oh boy. Oh yeah, I remember reading this one. Okay, yeah, let's dive into this one. This is one again. Fasten your seatbelts. So, well, you know what? I'll read it, let it sink in, and then I'm gonna come back around and show you just how screwed you are. I love that one. It's kind of like you're gonna get screwed. You don't know how bad yet, and then it hits. It's just that wonderful thing there. All right, so except is provided by subsection B, a person who is entitled to receive property or an interest, and please pay attention, guys, property or an interest in property from a descendant under a will by inheritance or as a beneficiary under a life insurance contract and does not disclaim the property under Chapter 240 Property Code may assign the property or interest in property to any person. B. An assignment of property or an interest in property under subsection A by a child support obligor is barred to the extent the assigned property or interest in property could be applied to satisfy a support obligation of the obligor that has been administratively determined as evidence by as evidenced by a certified child support payment record produced by the Title 4D agency. The same ones, the knuckleheads that couldn't get their stuff together before. Same guys. By the Title 4D agency in a Title 4D case, or confirmed and reduced to judgment as provided by Section 157.263 Family Code. The section Title 4D agency, meaning the jerk-offs at the OAG. Blah, 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 blah. The party executing the waiver may sign the waiver using a digitized signature, whatever. Final order and proceeding under, okay. Social security number, blah, 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 email. Each, okay. I'm just trying to make sure we got anything. Flavor of defense, yada yada yada. Security process, crimes and nose. I mean, this is all kind of just the nonsense here. Okay, blah, blah, blah. Okay, application of guidelines to children of certain disabled obligors. In applying the child support guidelines for an obligor who has a disability and who is required to pay support for a child who receives periodic benefits as a result of the obligor's disability, the court shall apply the guidelines by determining the amount of child support that would be ordered under the child support guidelines and subtracting from the total amount of the benefits or the value of the benefits paid to or for the child as a result of the obligor's disability. If a child for whom the obligor owes child support receives a lump sum payment as a result of the obligor's disability and the payment is made to the obligee as the representative payee of the child, the credit for the lump sum payment must be applied as provided by Section 157.009. Hope that's sinking in, guys. Okay, so credit for payment of disability benefits in addition to any other credit or offset available to an obligor under this title. If a child for whom the obligor owes child support receives a lump sum payment as a result of the obligor's disability, and that payment is made to the obligee as the representative payee of the child, mommy, the obligor is entitled to a credit. The credit under this section is equal to the amount of the lump sum payment and shall be applied only to any child support arrearage and interest. It's like a Rule of 76 loan. What the? Anyway. And interest owed by the obligor on behalf of that child at the time the payment is made. The credit under this section may not be used to reduce the amount of a periodic child support obligation ordered under Chapter 154 that has not yet accrued. Because, yeah, they have to keep that money train coming in. All right. Section yada yada yada. Family code or amendment is filed if a motion, because they've gotten rid of for enforcement, requests a money judgment for child support, medical support, or dental support arrearages. The court shall confirm the amount of arrearages and render cumulative money judgment as follows. Oh God, this is awesome! I am so glad I got snipped. A cumulative money judgment for the amount of child support owed under subsection B. A cumulative money judgment for the amount of medical support. Okay, blah, 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 blah. In rendering a money judgment under this title that includes child support, medical support, or dental support arrearages, the court may not reduce or modify the amount of arrearages, but in confirming the amount of arrearages may allow a counterclaim or offset as provided by this title. And then, let's see, family code is amended. A lien is effective until all current support and child support arrearages, including interest, any cost, and reasonable attorney fees, and any title for the service fees authorized under Section 231.103, for which the obligor is responsible, have been paid, or the lien is otherwise released as provided by this subchapter. God, I hope you guys are listening. I hope y'all are listening. Family code is amended to read as follows. If the court lacks jurisdiction over an individual, doesn't matter. Let me just sum that up for you. The court is not precluded from making an adjudication of, there's that word, adjudication, very important word, for making an adjudication of parentage binding on another individual over whom the court has personal jurisdiction. Oh, wait a second. Oh, wait, I got to read this. Hold on. This is going to be interesting. I hope, I know it's probably mostly dudes on here. You might want to bring your, if you're remarried, you might want to bring your, the old ladies in here. If the court lacks jurisdiction over one individual, the court is not precluded from making an adjudication of parentage binding on another individual over whom the court has personal jurisdiction. Yee. God, I am so glad I got snipped. So you may not delay the adjudication described by subdivision 1 solely due to the lack of jurisdiction. Okay. Let's see. I'm just kind of going through here. So let's go back to the top here and just dissect this a little bit here. And again, anybody wants to disagree with me, offer commentary, maybe you have a different slice of this one. This is okay. So let's just reread parts of this. Let's see. May assign the property or interest in property to another person. B. An assignment of property or an interest in property under subsection A by a child support obligor is barred to the extent the assigned property or interest in property could be applied to satisfy a support obligation of the obligor that has been One, administratively determined as evidenced by a certified child support payment record, confirmed, blah, it does all that stuff. So, um, this is what we got here. So, well, okay, let's just read the first part. And again, I hope you're following along. Okay, so acceptance provided, blah, 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 section B. A person who is entitled to receive property or an interest in property from a descendant under a will by inheritance or as a beneficiary under a life insurance contract and does not disclaim the property under Chapter 240 Property Code, and that's got some little bouncy things in there as well, may assign the property or interest in property to any person. Way I'm reading this, and please tell me if I'm wrong, is in the olden days, money that you received, you inherited, was the child support agency couldn't touch it. This right here changes that. So, you inherit money. Will inherit money. Now is child support can go after it. Get ready, guys. I mean, this is how money hungry these pieces of trash are. This is where we're at. So your grandpa Jones, dies, leaves you, $10,000, whatever that money is. Attorney General can take it with a smile on their face and apply it, the way they're going to apply it. They own your ass. Hope that 2 minutes of fun with the sugar mama was worth it. All right, so I hope everyone's paying attention to this crap. This is how serious it is. Let's see. I want to do that. Yeah, the disability thing. So basically, you get into a car accident, messes you up, you can't do whatever. You're and then so you get J.G. Wentworth or whatever. You get a lump sum payment. Boom, they can take it and then apply it however they want to. I mean, this bill here, HB 2246, man, gonna tear you a new one. And again, I'm hoping I've somehow read this wrong, but people have followed along with me here. They're going to be able to take your inheritance and whatever money they want to, no matter how you get it. It's all off the table. They can take whatever they want from you. All right, and we're letting them. That's the other fun part. We're letting them. Okay. All right. So, Smithy's on a roll here. He's got 2. Let's see what the Smithinator's got going on here. He loves that. He's a Title 4D guy. He likes writing that word. So, relating to certain Title 4D cases and other cases with respect to child support or Title 4D agency services and to practices and procedures for the operation of the Title 4D agency. Blah, blah. Oh, good old estate codes. Class 4 claims are composed of claims for the principal amount of accrued interest and delinquent child support and the child support arrears that have been A, confirmed by as a judgment or determination of arrears by a court under Title 5 Family Code or administrative determined as evidence by a certified child support payment record produced, blah, blah, blah. Those same idiots that can't keep their crap together, which requires a bill to come in to save these guys from going to jail, which probably won't go anywhere because it would help dads. Let's see, the court, amendment section. All right, court shall order the payment of child support, medical support. Okay, they got to insert all because 5, 10, or I think it's like 5 years ago, the way it used to work with child support, for those who don't know, hopefully everybody does, but it was just child support, and then in order to get more Title 4D money, to help the children, they dumped in medical support and dental support and kind of screwed things over. And then it makes it sound like they're ordering you like you didn't do it all along on your own. I remember my whole thing. I was like, shut up. I've been supporting my kids, medical, dental, every which way since they were born, since before they were born. And this just, anyway, total nonsense, bunch of ass hammers. All right, so employment services related orders for unemployed or underemployed obligors. Oh, we're going to see what's going to happen here. When establishing, modifying, or enforcing a child support obligation, a court or Title 40 agency may render an order requiring an unemployed or underemployed obligor to enroll and participate fully in a program available in the obligor's community that provides employment assistance, skills training, or job placement services, or work, have a work, have a plan to pay child support, or participate in work activities appropriate to pay the support obligation. And then an order rendered under this section is enforceable as provided by Chapter 157. Okay, that's dumb. Okay, so this section here, so actually, um, there's actually already. Oh, you know what? There's a title in Title 4D funding. There's a piece there. It's the Get Back to Work or whatever part of the Title 4D funds that if they work with you and provide programs to get you to work. So you can, of course, pay child support, and that's at the federal level. And there's a Title 4D component in there as well. So versus like having ways to do that, they're basically going to court order your ass to get a job, basically. And we all know that number two is going to be the only one that they're going to be doing it, which is just work. I don't care how, get a job. So that's so they can try to satisfy that part of the Title 40 funding. Good stuff. Okay, a lot of dumb crap there. Except as provided, support order may be modified with regard to the amount of support order loaning as to obligations occurring after the earlier of the date. Okay, whatever. All right, let's see what we got here. We got some underlying stuff. The release or return may not operate to prevent future action to collect from the same or other property owned by the obligor. B, a release of the child support lien filed by the Title 40 agency under this section does not require verification. Oh, nice. Same idiots that can't get your payments right. They can. It doesn't. Yeah. Okay. Good stuff. Release of child support lien filed in this section does not require verification. Okay, so the different sections there. So a copy of an order rendered to 40 agency. Yeah, this is basically increasing their judicial actions. All right. The second remote communication includes telecom. Okay. Unless a party files a written objection and accept as provided. Okay, so this is that. Oh, this could be interesting. Unless a party files a written objection and accept as provided by subsection D, an associate judge. And again, hopefully everybody knows that with associate judges, you have 7 business days to argue against whatever judgment they come down with for that if you think you really got screwed over. But anyway, the associate judge appointed under the subchapter may conduct a proceeding or perform a judicial action authorized under Section 201.104 from any location in the state using remote communication. Associate judge may require or authorize a party to participate. Proceeding authorized. Okay, they're going to make you. All right. Respondent is entitled to appear in person at a final hearing that may result. And if okay, of course, this I guess we'll call this like the George Sedano law or something like that. But here, a respondent is entitled to appear in person at a final hearing that may result in a finding of contempt or revocation of the respondent's community supervision under Chapter 157. The respondent may waive the right to appear in person at the hearing, in writing or on the record. Unless the respondent waives that right, the associate judge must also appear at the hearing in person. Yeah, so what a lot of these guys do when they're really wanting to put the screws to you, they don't want to do the remote hearings, or if they're going to throw your ass in jail, they're basically wanting to put in a law here that you're required to. There's a finding of contempt. So again, when those few times that we've actually been able to watch what happens during these complete shit shows, we see judges being made to look like the complete asshats that they are, and so they're obviously wanting to put a bill in here to stop that so they can bring people in. I would say, if anybody's going to write on this one or whatever, put a language in there that says, these remote hearings, they need to be available on, YouTube or for the public to view on YouTube and not, do all other stuff. All right, so they're putting a thing in here that's interesting. They're going to adjust the support obligation of incarcerated obligors provided by section yada yada yada. So for Texas, if you go to jail, you still owe the same child support as if you were working a 40-hour work week. They don't care. They don't even reduce it. I thought it was funny is Obama back in the day, the videos on the Pissed Off Parents site under videos talking about fixing that because it was stupid. A guy goes to jail. Obviously, he can't work, especially the same amount he's getting, and usually he's thrown in jail because he can't afford to pay child support. So it's one of those. It's kind of like the bank charging you an overdraft fee when they know you don't have the money to pay anyway. But they're, I guess, looking at putting a section in here to fix that. They got a lot of crap in here. See, dismissal of certain claims against Title 40. Oh, good God. A court may dismiss a cause of action asserted in a suit filed against the Title 40 agency or an employee of the Title 40 agency pertaining to the powers or duties of or services provided by the Title 40 agency under this subtitle if the court determines the asserted cause of the action is frivolous or malicious, fails to state a claim on which the relief may be granted, or seeks monetary relief from the agency or employee from which immunity applies. So, again, they're trying to get the qualified, or well, immunity. I was going to say qualified, but so basically, this is what's going to happen if this part goes in. And I would say people need to, write when they write in on this thing, or if they're going down, that what this is basically saying is that the Title 40 agency is doing stupid crap, whatever, and you're like, no, I'm going to, push back against the Title 40 agency. The judge, who's in league with the Title 40 agency since his retirement comes out of it, is like, yeah, no. And again, we see this all the time. I mean, at the appellate level, we see these yahoos all the time. They're like saying, yeah, I know you have a complaint against me. Yeah, so what? Boom. And then they cancel these things left and right because, again, they're judge, jury, and executioner. This is ridiculous. I mean, this is something I would say in this bill, HB 2247. I would definitely put some language in there to say, yeah, this is stupid and should be removed. Okay, so Title 40 agency shall distribute a child support payment received on behalf of a child placed in substitute care as described by section blah 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 to the appropriate state agency in accordance with the applicable federal laws or regulations. So yeah, they're just going to keep all the money. Let's see, administrative adjustment of support obligations during obligors incarceration. So I guess, and this is, just so we know, because right now when they throw you in jail, they do it for just less than 6 months, because after 6 months, then some things kick in. Right now, it's they're going to reduce the obligation when they're putting in the slammer for 180. So get ready for 179-day contempt of court, dump your butt in scenarios. So that's basically all this is going to do. I mean, it looks like what happens is if you've been put in jail, prison, whatever, they're going to adjust it. Blah blah blah. And okay, they're going to put it to your net resources during incarceration. I don't know how much you get paid in prison. Well, funny thing, actually, I did a report that actually no one watched, but the federal penitentiary rules or whatever, they're actually pushing through a law right now where any money that prisoners get in jail that gets donated to them or whatever, the Office of the Attorney General can take half of it, or 75% of it, and use that to do whatever, to pay child support or do whatever they want to with that money. So if you know someone that's in jail and you send them $100, they can take $75 of that and and just right off the top, and then do whatever they want to with it. And then so the person in jail only gets $25, just so. And they're putting it through that right now. I did a kind of report on that, I guess a month or so ago. No one watched it because it didn't apply to them personally. It didn't hit the feelers the right way, but that's coming, or that'll probably be happening. Family. Okay, so yeah, so all this stuff is true unless it's family violence. Yet another thing, when they do this silver bullet crap on you, yeah, don't sign, don't agree to anything because they're going to own your ass. I mean, so this all applies except for if it's if you're getting nailed for the silver bullet or something. A bunch of not. I mean, I'm just getting to that point where I'm getting just yeah. And this is the stuff. These guys. I mean, how many words can we throw in here? I'm getting really bored here, so I'm gonna probably just skip down to that last retroactive one and jump into, because this is all just complete horseshit. There's no certain time. Yeah. Oh, there's no time limitation. Yeah. Oh God, it's just. I mean, words. This is what they end up doing here. And again, they know that people aren't gonna. Wow, this thing just goes on and on and on. This guy is just. I'm gonna get paid by the word. Yeah. If you want to read it on your own, I got the links in there. Knock yourself out. It's HB 2247. I'm kind of done with it, to be honest. All right, let's get down to the money shot here. Oh wait, relating to the prohibition on following an individual and tracking or monitoring individual personal property. Yeah, you might want to read that on your own. I'm gonna get down to Cook's thing here and some other crap, but prohibition on following an individual and tracking or monitoring an individual's personal property. Yeah, so basically, yeah, if the ex or whatever you're in a divorce situation, don't throw a thing on their car or whatever. You get in trouble for it. It is what it is. All right, money time. Here we go. Cook's bill, what we've all been waiting for. Okay, so again, this is carbon copy of the other what 3, 4. I think we've already went through four. All this is the fourth one. So the suit between parents, and I'll do a quick summary, then I'll jump into my objections to that. And anybody else wants to chime in, great. And you know, you're limited to like 3,000 words on the actual form, so I try to do it. I try to do my rebuttal or my response with kind of that in mind. It was still wordy, but anyway, acting in the best interest of the kid. Wait, is this the one? Oh wait, this I screwed this one up last time. This is that best interest of the kid statute. Never mind. Sorry. Conservator. Oh, okay. Let me reread this one. All right. Suit between parent and non-parent is rebuttable presumption that what in a suit between a parent and a non-parent. What? In a suit between a parent and a non-parent. What the hell is that? This makes absolutely no sense. I was going down a completely different path. All right, so we're talking about the best interest of the child. The best interest of the child shall always be the primary consideration of the court in determining the best interest of the conservatorship and possession of and access to the child, which they can't really even define it. It's kind of whatever the hell they want to, whatever gives them the most money. So this is the part that's throwing me off here. And people, if you're going there, kind of, bring that up. But in a suit between a parent and a non-parent, it is rebuttable presumption that a parent acts in the best interest of the parent's child, and it is in the best interest of a child to be in the care, custody, and control of a parent. Oh, okay, all right, all right. I was brains going in too many different directions. Okay, all right. In a suit to which this chapter applies between a parent and a non-parent, the presumption in section 153.02b applies unless the presumption has been overcome in the most recent final order regarding the child who is the subject of the suit. The presumption shall be deemed to have been overcome as to a given parent if, in a prior proceeding and with respect to a child who is the subject of the suit, the order sought to be modified expressly stated that the presumption was overcome on the issue currently before the court. The parent was neither named as nor continued as a managing conservator in the most recent final order, and the parent is not being named as a managing conservator in the final order in the current case before the court, or the order sought to be modified resulted from the parent's voluntary relinquishment of actual care, custody, control, and possession of the child to a non-parent. Okay. I'm kind of thinking Chris Clay, quite honestly. Those who don't know, Chris and his ex wife, girlfriend, whatever, they had a kid. They had I think it was a 40-60 split. She had primary. Anyway, she started shacking up with this dude, and then I think it was 6 month time frame. She actually passed away in a car accident. And then the boyfriend of the deceased girlfriend, the grandparents of the old lady, they were the ones that were behind the whole thing, but they had to, create that, whatever. But they brought suit wanting to get equal parenting, oddly enough, with alongside Chris Clay, the natural parent, biological parent, and this thing went all the way to the Supreme Court. Actually, if you go to pissedoffparent.com, I have that video where it talks through, and you listen to way these people talk and how they think, and you just know just how completely moronic and stupid they all are. That they actually like think and talk this way. I mean, a lot of this stuff here that I talk about, I mean, the average person looks at it and goes, "These people are just completely brain dead." This is how they live their lives. This is what they believe. What they honestly, without, I mean, this is how they live their lives. They think and breathe this stuff, and they believe it. There's no other way around it. Um, it sounds like, yeah, here they're talking about, best interest, but the thing I guess that concerns me though, I'm just trying to think of different cases and kind of where this would be applied, but it looks like, so if the courts have stripped a parent and made them a non-parent, because I mean we have the voluntary relinquishment part, but we have situations where the courts have stripped a parent of their rights, which actually happens fairly often. Then they're able to go ahead and do their stuff under the best interest nonsense that they like to spew. So I don't know. I'd be a little concerned about this one, quite honestly. Thank God my kids are grown. I don't have to worry about it. But yeah, I guess for everybody else, that's something to maybe consider. And the parent, it's just yeah, it's just weird. I mean, they've already established that. I don't even know why we have the bill, but I mean, it did eventually win out in Chris Clay's situation where they did uphold that Chris Clay is the biological parent, the only one remaining, especially, and it's the only reason he got custody because there was no other parent there, so by default he got custody, but it cost him like $150,000 at last count. You can watch the video and see the numbers. It was actually redonkulous what he had to go through, and it wasn't even over then. I mean, those were temporary orders. That's how crazy this got. But they were actually giving weight to a 6-month boyfriend. That's where we're at. That was years ago. That's where our Texas legislature, and this is where people, this is how their brains operate. You can't fix this stuff. Let's see. Let me look at some comments here. Real quickly. Let's see. We got William Salazar. I think grandparents should have some rights, but not at all the same level as the parent. Yeah, I mean, there's really not a grandparents bill. I mean, some other states have an amount of that, but and I think some of the earlier bills I was talking about did mention like, but you could read grandparent into some of those things, but yeah, I mean, of course, in today's day and age, I think grandparents, that loving grandma, grandpa, whatever. But here, just something to think about. Do you some of the people you've grown up with, people that are like, I guess my age now, some of the wackos out there? I don't look at them as like the typical grandparents. I would be scared of them, of how they think. I wouldn't want them around my kids. So the grandparents of old, I think, are is kind of a forgotten thing. I mean, the ones now are just and if you think about it, I mean, you got grandparents at 45 even and younger. I mean, it's just crazy with kind of the way things are going. But yeah, I mean, there should be an amount of grandparents, right? Personally, I mean, because it does, grandparents do play an important role in raising a child. I mean, every parent does. That's why, one, getting people's head out of their butts and being good parents is one thing. Two is keeping these damn courts away from you because they screw everything up. It's got to, I don't know, got to figure out a way to make it better. And I would just say a number of these bills that are going through, they're talking about trying to legislate their way out of this nonsense is not it. Anyway, that's that one. Let's see here. I'm gonna skip over Dutton. Well, maybe I don't know. I'm in for the long haul here. Dutton, he's again the chair, but this is this is child support and support of certain adults with disability. Yeah, that's another thing too. I mean, I hope everybody knows like normal situations when the kid turns 18, child support ends. Well, if they have a documented disability, lifetime, so lifetime paycheck. Let's see what they're wanting to do here. Okay, the heading, subchapter A, chapter 154, family code is amended to read as follows. Subchapter A, court-ordered financial support. They don't want to call it child because it's an adult, I guess, of a child or adult with medically determinable disability. Okay, so they're just changing the language there, whatever. Court may order either or both parents to support a child in the manner specified by the order. That could be interesting, having both people pay child support. As provided by subchapter F for a child who is an adult with a medically determinable disability. Okay. Court may order each person who is financially able and whose parental rights have been terminated with respect to a child in substitute care from the dependent has been appointed managing conservator of child for a reason described. Okay, this is yakking on and on. Nonsense. Living in adult. Okay, so yeah, that'll be interesting. What they make as an adult, they make dad and mommy pay child or pay adult support. That would be interesting to see how that worked out. And the amount to be determined by the court. Yeah, as much as possible. I got to figure out if this is going to be part of Title 4D, and then it'll be a lot. Disability. Okay, I'm scanning through this because we've already been on for quite a while, and I'm just kind of like I'm wanting to get to the good stuff. Oh, Title 4D. Boom. There we go. That explains why it's being done. Okay. So yeah, this will be part of Title 40 funding and more money, more money, more money. All right, good stuff. Attorney's order. Yada, yada, yada. Okay. Yeah, they'll figure out a way to screw somebody over. Okay, I'm going again quickly. That's why, a lot of these bills, like racing through them, it's going to be, I don't know, kind of hard to do all that. Services, parent-child relationship. Oh. HB 4062. Someone was mentioning that one earlier. Yeah, all right. So, Harris of Anderson. 4062, the child custody evaluator shall create an audio or video recording of each interview and the evaluator conducts with a child who is the subject of a suit seeking conservatorship of, possession of, or access to the child unless the interview is conducted in the presence of all parties to the suit. All right. Okay. I'm like, sure. That'll be interesting. I mean, kind of good to have because then what ends up happening to these evaluators is they come back and they go, yeah, he hates dad. He wants to go with mom. Give me my check. At least here we have a recording of that. That could be interesting. Now, hopefully, parents can get a hold of it. All right, so that covers that one. Where am I? HB. Okay, bills added after last posting. Yeah. Oh, thank God. I thought I screwed up and it wasn't all this stuff had led up to nothing. All right, now we're getting to HB 3072. This is one that got added in after the last posting came out. All right. This is the one. Oh, wait. What the heck? God, there's too many bills. Best in the channel. Wait, hold on. Suit. What? Oh, okay, wait. This is the one. I keep screwing this one up. Where's the parent, non-parent? Hold on. If not, I'm just going to bring it up anyway. Bills deleted after last posting. Wait a second. Wait. What have they done? Okay, did that. All right. Boy, I'm having too long of a day. All right, let's go back here and let me get my bearings. 1734. I mean, let's look for 1734 because apparently I jumped right over it. All right, so Leach's bill. Darn it. Okay, part of my joke's not going to work. So this is the too many damn bills run through my head. This is the bill for retroactive child support. It's going through, again, shortening the whole thing up keep it kind of short here, is that from conception forward, mommy or the guy is dumb enough to sign the paternity the birth certificate, he's on the hook, goes in, they basically dump a judgment on his ass. It doesn't get interest for the first year, and then 6% per annum. After that, if there's a genetic testing request, it's in utero, which currently, in current Texas law, everyone you cannot get an utero DNA test. Texas law prohibits it, but this bill here actually modifies that language. Yeah, right here. Where the heck is it? Too many screens open. I may have too many screens open. Where the heck? Yeah, I've got way too much. You're just gonna have to believe me, I guess, because I can't find the. Oh yeah, here. Oh no, here we go. 160.502. If a request for genetic testing of a child is made before the birth of the child, the court or support enforcement agency, ooh, they don't even have the power to do it, may not order in utero testing. So even the mighty OAG can't do it. But anyway, so the only way to do a DNA test is if it's done by the request of the mother, and the physician who's performing the genetic testing certifies to the court that the testing would pose no risk or harm to the pregnant mother or the child. We have the data, just to let everybody know, we have data out there that shows at 7 weeks you can get an utero DNA test and zero impact to mom or child. So we have that. Proceeding for before birth, okay, unless the pregnant mother commences the proceeding, so she's got to be the one that kicks off the whole thing and get that to get everything rolling. And then this is just documentation nonsense. Okay, I'm just kind of quickly going through that. So here is what my challenges to that have been sent over to Robert and I think it's just a Robert so far that we can kind of talk to the different pieces. But so right in here, am in opposition to HB 1734 for the following reasons. While this bill specifically references adjudication or a voluntary acknowledgement prior to becoming valid, there should be language inserted into this bill that requires a DNA test confirming the father's parentage upon request of the presumed father, not the mother, the father. Because, well, I'll get into that part of it. Current data for DNA testing shows two alarming results. One, 30 to 33% of results reveal the presumed father is not the father, and the average retest that a mother will go through to find out who the baby daddy is 4. It actually surprised me. I didn't think it was that bad. I thought I thought it was like maybe 1, like you didn't know, but 4. That's crazy. So then the kind of tack or the position I took on is by ensuring that the correct biological father is listed on the birth certificate, the child can be informed of any medical issues that the child would need to prepare for, high blood pressure, various cancers, stuff like that, as well as ensuring that the correct person will be supporting the child. And then also, I didn't write in here, but the birth certificate is a legal document. Shouldn't it be? We have the technology. This is like $6 million man moment here. We have the technology. Just do it. It is not. It's not expensive. Just do it. And then there's no question. There's no nothing. And the child will then know. Hey, I've got a propensity to high blood pressure, cancer is one too I can think off the top of my head, or pick my nose, whatever. There's that generational thing, but that's a big one. If they really gave two shits about kids, that should be a no-brainer. And 33% of all DNA tests are the daddy is not the daddy. So you got that going there. All right, so section 1B, that's the in ordering retroactive child support under this section. And I basically tried to put that in there just so we can kind of keep track of everything. The could shall apply, or I'm sorry, in ordering retroactive child support under this section, the could shall apply the child support guidelines, and then I reference prenatal and postnatal. The assumption, now here, this is where one where I start going on that whatever, and I kind of go off on some other stuff, but the assumption here is that the mom is already on some kind of health insurance, at least through Medicaid. And as I understand it, and as I've been told a number of times, in order for a chick to get put on child support or to do the child support process, they require you to get on Medicaid. Medicaid covers all your prenatal and postnatal crap. You have health care. So I don't understand, and again, if we get to the real, what I want to, force, if they even push back on that, is I want to force a comment I made lower on there that this is all about Title 40 funds. Everyone should know that the whole Title 4D, all this we care about kids nonsense, it all stemmed back from Title 4D because it was created because in the late 60s when no fault divorce passed, the divorce revolution, everybody got crazy and independent. All these chicks, divorced their husbands, and they went, well, I got nothing, so they go on welfare. Well, each of the states are going bankrupt because all these chicks are on welfare, being useless, and they're like, we got to do something. So they get hold of the federal government. Federal government says, hey, start going after the dads. And so they went, oh, great. And then, the money will happen and a whole bunch of stuff. You can go on the website and read all about it. I even have cartoons and videos for you for the folks that love cartoons. Make it edutational for everyone. But that's what happened. And, I would love to have them push back and say, well, the whole reason it isn't about kids. I'd love for them to say this isn't about kids. This is because we're getting our asses handed to us because all these chicks, and I talk about it further down the thing, that 63% of all millennial women, which are currently the ones having all the kids, 63% are single moms, which should scare the absolute shit out of everybody. For as a society, that is ridiculous. The number of single moms, and from the other data that I've got, at least especially here in Texas, is that they're all unemployed. None of them are working. They're little baby factors. They're pumping out kids. They're not like doing anything. And again, people are gonna get all ticked off. I blame. I also look at the chads and the idiots that are impregnating these idiots. I mean, it's just a circle jerk of idiots. Of course, there's the other part of it that what 60-70% of all unpaid child support debt is owed by people that make less than 10,000 a year, i.e., unemployed. Well, let's say deadbeats that are never going to pay anyway. So yeah, there's got to be another solution, not this, not to break the backs of people. Anyway, all right, so receiving 20% of the okay, so they should be getting at least Medicaid. So receiving 20%, which we all know it's more, but 20% of the father's income from conception to birth literally makes no sense. Further, with previously drafted bills, they inserted cribs, diapers, mother's lost wages, and postpartum. Those things were referenced. The current bill's ambiguous language, this prenatal and postnatal, that's all code. That's all. This is that famous attorney nonsense where they smoke and mirrors. Oh, it's just prenatal and postnatal. Just some pills. Blah blah blah. No. They're wanting to dump, and it's all left up to the judge to then say, nope, this is what we're doing. Bam, and I do have some anecdotal proof of that. So anyway, the current bill's ambiguous language could easily be interpreted to cover limitless pre and postnatal items, i.e., decades-long postpartum event. Personal, funny now to me, true thing. My ex-old lady, when her goofy ass took me back to child support court, the kid, the youngest was 10, 14, 14. Yeah, 14. Trying to remember, again, get this age, is what happens. 14 years old. That goofy broad told the judge that she still suffered from postpartum 14 years later. Don't tell me for a second that these chicks are not going to look at this as a gravy train. They already do. And they're, of course, all too happy to solve. I mean, you've seen all the other nonsense, all these other bills that are going through. This is what's going to happen. Do not be fooled by this pre and post natal and she just need pills and whatever. No, it's going to basically to supplement her deadbeat lifestyle, plain and simple. Anyway, let's see. Also, equitable. Good God, we've all heard the word. Okay, guys, it says in the language there, equitable. I'm going to say this real slow for y'all. Equitable family court is a court of equity. Criminal courts, criminal, civil. Family courts are courts of equity. How freaking equitable is it for y'all? Not very, I'm guessing. That's why we're all here at almost 9 o'clock at night listening to some old fart that should be in bed taking a nap reading off a damn letter. Seriously, equitable. I would not be, that hearing the word equitable from these idiots scares the crap out of me. Okay, have a meeting ranging from 0 to 100%. Actually, Robert, if you're still on and haven't fallen asleep yet, I probably should have put like 150% because we know how these idiots operate. Anyway, it shouldn't be certainly not left up to a judge's discretion. All right, so the next section, Section 1C, the interest section. This is one where I kind of went, while appreciative of the 6% per annum delay, so each of the bills say, at least the House bills, the Senate bills don't. That one, they're like, screw you, we want the 6%. But the House bills, all of them give you a 1 year time frame for that 6% interest rate, which will probably be like a rule of 78. With anybody knows what the rule of 78 is basically when you get the loan, it say it's a 5-year loan. Forget we're talking about this, but 5-year loan, and those $5,000 at X% interest. Every payment you make, you pay the interest off first before you ever touch the principal. I probably will not shock me that that's what we're going to try to do on this one. Anyway, I put it here, think about the damage to younger people already saddled with life's challenges. An 18-year-old presumed father will have not only a lump sum judgment child support debt levied on him in his credit report for the next 18 years, he's also going to have the ongoing 20+% of his income taken from him while he's trying to support himself, his family, if he's even allowed to be around the kid. At the very least, lump sum debt should not have an accruing interest and shouldn't appear on his credit report. It shouldn't be part of Title 4D. But when I wrote that part in there, think about it. It's going to be some young kid, or younger person. They're going to walk into court, because this is how it's going to work. Depending upon what bill goes through. So, you're the daddy, blah, 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 you sign the birth, but whatever, he's the dad. Judge is going to look at him and go, yeah, I'm feeling $20,000 or $10,000, whatever number this old fart pulls out of his ass. He's going to grab, someone stole my there you go. Damn kid stole my gavel. Going to grab his gavel, remove it from his ass, and slam it and tell you $20,000. That's how this is going to work. It's not going to be based on common sense, because I think everyone here knows judges don't work off of common sense. But he's going to go $10,000, and 6% interest accruing for the next. So it's going to appear on his credit report. I hope everyone understands how credit reporting works, which is another weird thing. That's a debt, yada yada yada. But this is where we're at today. So his credit report is going to say $10,000 debt. Child support debt, which is going to be, of course, screwed up because the OAG, they're a bunch of morons and can't get their data correct. So they're going to have that. So he's going to try to get an apartment, get a car, try to live his life, get a job. All these things are, you need to have a decent credit report for. Getting an apartment, house, whatever. Hopefully he buys a car in cash, but, I know Dave Ramsey here, but, whatever. Getting a job. All the jobs, or most of the jobs, they require you have a good credit report or you don't get it. And we're going to basically dump this on a young kid who, let's just be honest, the kids today, they don't have the cojones that at least this old fart does, or folks in my age group. Of course, a lot of them morons. They're about as stupid as a box of rocks anyway. But these guys, they're not built for bad times. And we're going to saddle this kid with all of this stuff under threat of jail, and then expect him to perform and be a good dad and raise his son. He's gonna be working 20 jobs trying. He's probably working 3 to even just provide at all, and then we're gonna settle him with this. It makes sense, and certainly, and I talk about being more sexist, is the rest of these bills and all that stuff, giving the pussy passes out and stuff like that. You can tell that they hate men, every bit of this thing. But anyway. Okay. So then the next section here, section 3B and section 4, 160.1. This is where it gets kind of funny, I hope. Request for DNA testing. I put there, these sections are absurd for a couple reasons. I limited what I thought. There was a lot more I could have said, but I was limited on words that I could use. And since I won't be reading it to these morons, I didn't want to get in too much trouble, but there's so much I wanted to say about this. I had a lot more the absurd reasons. So, 1, the only allowable request is by the pregnant woman. Okay, 33%, again, this is common knowledge of DNA test results that reveal the presumed father is not the dad, with 4 attempts on average to find the right ones. In short, a woman will never request a DNA test. The second one kind of goes into the one. I'll kind of go into that. Has any of you, and Robert, if you're still awake, I want you to look these fart knockers right in the fucking face and go, have any of you morons ever watched an episode of Maury Povich, Cheers, which is out of Dallas, Paternity Court, Jerry Springer, Judge Judy, Steve Wilkos, all those? Really? Are you kidding me? Paternity fraud? Hello? These women will not do DNA tests. And to actually, it was a waste of ink to write in there at the request of the mother. That's absurd. And then, of course, and then when I trying to regather my thoughts here, but while the majority of the bill is sexist and anti-family, and I would debate anyone that would argue anywhere close to otherwise on that, it is a completely sexist bill, and it's definitely anti-family. Can you imagine trying to have a relationship with your girlfriend, spouse, whatever, after this, after getting, we're gonna dump a $10,000+ judgment on your ass. We're gonna go after. We're gonna under threat of jail. We're gonna treat you, and you know they're not gonna bring him in there and treat him nice. They're gonna treat him like shit, like they normally do. Um, that's not gonna promote family. That is how high conflict. I mean, for the morons that are on this thing, that's how you get conflict. Hopefully, well, I know you guys are too stupid to figure that out. This you're creating more problems, but you really should put in that section the man requests it. And that's the way, and it should be done automatically if you really cared about kids and not your damn pocketbooks, but we all know. Anyway, this section is beyond ridiculous. This bill should be amended to read, okay, upon commencement of a retroactive child support action, a DNA test from a recognized testing facility or whatever you smart folk want to put in there shall, not may, shall be ordered and required. That is a requirement. I mean, some of my, and I think others being pissed about some of this stuff would go away. If you weren't, we didn't know what we knew, the bamboozling a lot of these people. If the guy is the one that, knocked the chick up, then he deserves what he gets. I mean, I've been telling people, hopefully other people, if you're going to not wrap it, I mean, we've had condoms for, like, God, decades. If you're stupid enough to raw dog some questionable chick that's crazy, which, by the way, it's a good number of them, you deserve what you get. Sorry that I'm not. You know what? Not even sorry that you're stupid. I mean, we've got condoms. You can get snipped. There's so many different ways to not knock a chick up. Don't do it. Good God, quit being stupid. But anyway, require the DNA test. That's going to solve a lot of it. That keeps the wrong dude, because what's going to be happening here is we're going to be suckering parents, which happens a lot, 30 to 33% of the time, at least. This is the ones where we've ordered them, where we've gotten past all the other nonsense and got it ordered. We know how Texas is. You guys don't like DNA testing because, God forbid, we find out who the real daddy is, not who the high earner is. It really shows where your, where your loyalties and all that stuff lie. Certainly not with dads. But the big thing here out of all that, the diatribe and rambling here, is that we can actually give medical info to the kids. Isn't that, I mean, this whole benefit of the child, best interest, I hear you guys rambling on about that nonsense. Wouldn't it be in the child's best interest to know who his biological father is? So one, he can have a connection. Two, he can get medical info on him to make sure he doesn't keel over at 20 from, from a heart attack or whatever. I mean, hello? All right, so get down to my other notable issues with the bill. The order of the man language in the bill. Okay, what if the man gets custody? This bill prevents, prima facie, the ability of a man with custody to receive child support. So, for the smart guys here, the way it's written, it says the man, order the man. So, if the man gets custody, the bill basically prevents the woman, by law, from paying the man. Stupid, sexist, moronic. Oh God, I'm getting pissed off. I had so many more, but again, limited on time and space. All right, so it is presumed that the man is providing prenatal care, and how much is really needed? I mean, really. Let's be real here. How much prenatal care is needed? There's no bookends here. So how will the courts evaluate that? I mean, let's get right down to it. So if she's getting Medicaid, or she's getting insurance, or he's paying for it all, How do you evaluate it? How do the courts evaluate that? I mean, the way it is now, if whatever money, because again, this is all Title 40 money. We already know what this is really about. It's not about kids. It's about Title 40 funds. And we know now that at any time payment is made to the woman, and it doesn't go through the OAG, it's a gift every single time. So how is this going to work? I mean, basically what it is that I guess the guy needs a nut, bolt, and then just goes to not be a part of the family law. I mean, that's what you're creating, legislative people. I mean that's what you're making. This is what these bills are going to do. You're going to further destroy the family that you oh, we care about family. You obviously do not. All right. Another thing is, isn't it customary for mothers to have a baby shower? They get a lot of this stuff, the prenatal items, cribs and all that fun stuff. I mean, don't they already get that? And again, this you guys kind of played yourself. You had all this ambiguous language in the earlier drafts of the bills, so we saw the game plan then you tried to smarten up, which and we kind of figured it out. So I mean, hopefully no one's going to be fooled by the prenatal postnatal nonsense that you're spewing now. I mean, the turd's out, you might as well flush it. This is kind of where it's at. So given the ambiguous language post prenatal, which is code for lost wages and all that other crap, this will greatly incentivize women to quit their jobs post pregnancy. That's going to cause all kinds of issues downstream. I mean, a chick's going to get pregnant, boom, she's going to quit if she has one, she's going to quit her job and never go back. That's what they're going to end up doing. And you're incentivizing, you're feeding the bears. I mean, legislative people, quit being dumb. I mean, this is a horrible bill. Okay, here's the next one. And I made a video about it. Nobody wanted to watch it because it wasn't about them, but it is about you. And I would encourage people to go back and watch the video from Indiana. And for the folks that will say, why don't you send it to me, or can you give me the information? Kiss my ass. I spent a lot of time and a lot of work preparing these things and doing lives and stuff like that. And if I'm not going to bottom shelf and baby feed you people, it's out there. Go find it. Anyway, Indiana already passed this bill a few years ago. Shocker. And as predicted, has become the clearinghouse of expenses costs that I've been talking about. All those things, all the Chicken Little, pie in the sky crap I've been talking about. Part of it, again, I'm not that smart. I just do research. I pulled a lot of this crap from the Indiana bill and what was happening. After they passed this stupid bill in their state, people went bonkers. And just all kinds of crap. The lost wages, they did the pre-postnatal thing, and they did it all. I mean, even attorneys there are pissed off about this because they are seeing, and this takes a lot for an attorney to be offended by dealing with snakes. Kind of shocker here, but they're ticked off about how greedy these broads are getting with getting money. So Indiana's already done this, and it's failing miserably. Don't do it. Okay. And finally, this part, the bill is sexist to its core. And the obvious issues arising from it with respect to how men, it clearly, it states in the statutes, and I'm not going to bring it up here, that, we are all equal under Texas law, which is complete bullshit. We know, the title, we know 94% of all the child support recipients are women. We know what's going on. We're not stupid in that sense. We're stupid in other ways, but we're not stupid in that sense. We know you guys are doing this for money. But the law does say, and if you guys pretend to even give two shits about the law, it says we're supposed to be treated equally. We should be having equal share parenting. We should be having equal. This bill is sexist. It talks about throughout it, man. Nonsense. I gave one of the many, but one reason up there why it's not a good. The law on its own is going to cause problems, especially when a man in the unlucky event or on the rare event that he gets the child, because mom's a crack whore or whatever. Which actually the earlier bill, the chick. Oh God. So the earlier bill I was talking about, it talks about that they don't get they get the pussy pass. If they're smoking crack. and they admit it and all other stuff, they don't get in any trouble. You guys have the balls to put that bill and then have this bill. I mean, you guys are just stupid. Okay, all right, I gotta pull back. I'm gonna have a connection. All right, um, kind of in closing here. While I understand the bill is meant to increase Title 40 funding, we all know 94% of all Title 40 recipients are women, and it's used to offset the 63% of single mom millennials who are living on the state's welfare rolls, and it's continually penalizing the backbone of Texas. Men, we are the backbone. Ladies, tough. Fat men, we're the backbone. Um, Going after us like you are legislators, that's not the solution. It isn't. We got to figure out a different way to go about fixing the issue. And I do go along with the Family Law Foundation that pamphlet they sent everybody arguing against the equal shared parenting bill, where most of it was complete nonsense. But the one that I'll go ahead and just take their number or take what they said. They said that a lot of these knocked up chicks are one night stands. There's other ways around this. But anyway, I think the better solution would be to pass the other bill. I said your other bill. This is Leach's, but I don't know why I was thinking Cook. And so Robert, changed that in there. But would be to pass the other bill that out there, the equal shared parenting bill is kind of what I was alluding to here. And for some reason, that bill still hasn't seen the light of day, which is making me little, was it not deja vu, but reminiscent of the HB 803 days, where basically the same thing happened, where the equal shared parenting bill just didn't even see the light of day until like the end, and you played your games, and of course we know how that works. But you want to get off the people off the teat and all that stuff, and you're not caring about Title 40 funds. Do equal shared parenting. Give dads the nod. We can do the job. We're not getting bills filed for us that we're smoking crack around our kids, and get it in the past to where it doesn't have to be reported. I can't believe you guys had the balls to even write that one. But all right, I'm gonna stop because I'm just I can go on for hours. So what can you do? All right, I'm gonna put in the chat. The chat on giving public comments. Now I'm gonna go and throw it out there and full disclosure, because that's kind of how I hit everybody. There's probably I want to say I'm gonna be a little tongue in cheek here. Probably not a chance in hell they're gonna read any of this crap or believe it. I mean, again, there's 5 total bills, 4 in the House, 1 in the Senate for retroactive child support. These idiots they've already decided on what they're gonna do. Full disclosure, we're too stupid to put enough of a pushback or really do anything that would cause them to change their minds. I mean, they are focused on that Title 40 funds, the more money, and they don't obviously don't care about the consequences. But I still can't get over that the meth bill. Maybe that's what you call it, the okay to smoke meth bill. They don't care. So I mean, but it's one of those where you at least got to get the bucket and try to empty the water out of the Titanic in hopes to save it. You got to at least you feel like you did something. But what I did is I put a link in here to the House public comments, and basically you put your information in, and from there you locate the bill that you want to talk about. I mean, you can do the whichever one you want. There's 1734, which is that bill we were talking about, and then you can go ahead and put your comments in, and then from there, mine kicked out of there already. I'll have to go back to that link. Good thing I saved it. Pop it out here. Comment. Oh, not let me do it. But you can go to that. Actually, here's the comment section. There we go. And you can go in there and put your comments. You're limited to 3,000 words, of which they won't read anyway. But you can let them know what you think. I'd say be respectful in the sense that you don't need to be nice or whatever. Just not threatening. Nothing stupid that's going to get you in trouble. But yeah, I mean, let them know. I mean, on each one of those. I mean, I know I quickly went through a couple of them as the evening droned on, but this is just completely insane. some of these bills, and of course the retroactive child support. At least you can say you did something. They're going to be hearing it tomorrow. So again, April 12th, which is tomorrow, 10:30 a.m. and then until final adjourning of that or recess, whatever the crap they want to do there. So you got all that time. I would run through the bills and put your comments. It doesn't need to be as eloquent. Of course, mine wasn't that eloquent, but you can put your thoughts in there. Tell them what you think. And if you have things that I didn't think about or other people didn't think about, throw that in there as well. I mean, it sounds like a plan. All right, that's pretty much it. Not a whole lot more to talk about. Of course, I've been going for 2.5 hours. Thank you to the guys that decided to hang out with me. If anybody's got any questions or comments or whatever, shoot that over. Looks like I tickled Joe's funny bone there. I'm tired of the nonsense. Treating people, these idiots like they're special. I mean, they're special, like special ed, but they're not special, and I'm sick and tired of it. And I'm not saying this to be rude, this part at least. I don't, they work for us, and it's not a, you work for me, who I work. Oh, I can't remember the joke now, but they're supposed to work for the constituents, not themselves. They need to be like of the people, and I can't imagine most of these bills here being for the betterment of society. I mean, the majority, there's like kernels in a few of them. Of course, I'm sure somebody's going to screw me over anyway. But the stuff there, it's all for the betterment of the state. I mean, the Title 4D funding piece of it alone, just the components, taking your inheritance, disability. I mean, all that stuff. That's not helping the people out. That's doing it for the benefit of the state and arguably for them in the back end deals and all the other fun stuff. That's not for the people. This retroactive child support. If they came out and said, "Look, here's the deal. We got a bunch of broads that are getting knocked up on one night stands, and they're stupid. A bunch of chads are pumping and dumping them, and they're the state's problems because for whatever." We're losing money on Medicaid, Medicare, whatever. We got to figure something out. Then hey, let's figure out what that is. Not let's break the backs further of men. And again, I argue back to the men too. Quit coming or quit one night standing these people. I mean, they're clueless. They have nothing to offer. You find women of value, which I know is few and far between. And again, flipping it around the other side. A lot of the guys today are stupid too, because again, it takes two to tango. And now again, a woman can do whatever the hell she wants to with the kid. Apparently, smoke crack and get away with it, and that's okay. But it's said over and over and over: women are the gatekeepers of sex, men are the gatekeepers of relationships. Women, the Tinder world, and all this other nonsense you guys are doing to keep your feelies going. That's caused all this. Stop it. Tell the guy no. Get educated. Do it on your own. This independent nonsense y'all talk about. Go do it, guys. Quit. Shacking up with these chicks. Get a relationship. Again, our legislature obviously is not trying to promote family values or promote family. I mean, it's painfully obvious. And I could have went into more detail on a lot of this stuff. So it's not them. It's up to society to fix this. I would ask people to go to pissedoffparent.com. Actually, I've updated it a number of times here recently. But under the Fix the Glitch section, I've laid out things that can be done that everybody can do independently and together to make this thing better. Get people off their dead asses to do it. Because again, waiting for baby daddy government ain't gonna work. Because you see how they're responding to it. I mean, when has the government ever done anything that's been like really good? Seriously, it's just ridiculous. Anyway, I'm sitting here droning on. Thanks for hanging out with me. I know I droned on. Hopefully, I was at least somewhat entertaining. For that, I got more updates coming down the road. Hopefully, I won't be doing like marathons again. But I'll let you guys know what we have coming up. Oh yeah, before I forget, let's see, where is the I'll try to get it out there once it's available. Here's the notice. Let's get back to the where is it? Live broadcast. Everyone should have this. I mean, hopefully everyone has it, but throw it in the chat anyway. If you want to watch it live, then I'll probably snag a copy of it and throw it out there so you can hear the tidbits because I'll listen to parts of it. For the guys and girls that are going down to Austin tomorrow, Godspeed. Definitely better people than me. Going down there and putting up with those yahoos all day and all the other nonsense. I wish you guys luck. And hopefully, hopefully some minds change. Love to hear any reports. Maybe we'll do a live when y'all get back. Go from there. But outside of that, everyone have a good rest of your evening, and we will talk at you later. Till then.